I am Bright Atobra Awusi. This morning, two separate suits filed at the Supreme Court are seeking a landmark interpretation of Article 66, Clause 2 of the Ghana's 1992 Constitution, which limit a president to 2 terms in office. The plaintiffs argue that the constitutional restrictions applies only to two consecutive election terms, potentially allowing a former president to contest again after sitting out full electoral cycle. As the apex court prepares to determine the matter, what could this mean for Ghana's future elections? Belinda Tetteh has more in this explainer.
Ghana's Supreme Court has been called upon once again to interpret one of the most important provisions of the 1992 Constitution, the presidential term limits. Two separate lawsuits filed by Ganiu Al-Hassan, a teacher from Pandai in the northern region, and Kenneth Kwabena Ajay Kranchi, an editor of the Daily Searchlight newspaper, seek clarity on Article 66, Clause 2 of the Constitution, which states a person shall not be elected to hold office as president of Ghana for more than 2 terms. Although the wording appears straightforward, both plaintiffs argue that the Constitution leaves room for interpretation regarding whether the 2-term limit applies only to consecutive terms or to any 2 elected terms, regardless of whether they are consecutive. The Attorney General has been named as the defendant in both suits and has 14 days after service to file a statement of defense. Mr. Al-Hassan, a teacher based in Pandai, is asking the Supreme Court to declare that a former president who has served 2 separate terms, non-consecutive terms, remains eligible to contest the presidency again. He argues that preventing such a person from seeking re-election would amount to an unconstitutional restriction on political rights. He also relies on Article 60, Clause 6 and 60, Clause 7, which deals with a vice president succeeding to the presidency, to argue that the Constitution does not impose a rigid or absolute interpretation of the 2-term rule. Mr. Kranchi, a journalist and the editor of the Daily Searchlight, on the other hand, is seeking 3 declarations from the Supreme Court. He wants the court to rule that the 2-term limit under Article 66, Clause 2 applies only after 2 consecutive 4-year elected terms. He also wants the court to rule that if a former president spends at least 1 full 4-year electoral cycle out of office, that break effectively restores eligibility to contest again, and also wants the court to rule that a constitutional prohibition is triggered only after the president has been elected and served too. This is not Mr. Kranchi's first legal challenge on the issue. Before the 2024 elections, he filed a similar suit seeking to stop the former president, John Dramani Mahama, from contesting. However, the Supreme Court struck out the case after he failed to file a statement of case within the required time, meaning the court never determined the constitutional question on its merits. The renewed legal debate has inevitably drawn attention to President John Dramani Mahama, although he has repeatedly stated that he has no interest in seeking a 3rd presidential term. The Supreme Court's eventual interpretation will not be about one individual. Instead, it will determine how Article 66, Clause 2 should apply to all present and future presidents. At the heart of the suit is the constitutional question that could define the future of Ghana's presidency. If the Supreme Court rules that only consecutive terms are prohibited, will Ghana's future elections see former presidents repeatedly returning to seek office after taking a break? Will the judgment strengthen constitutional democracy by clarifying the law, or could it weaken the long-standing principle of presidential term limits that has underpinned peaceful democratic transition since 1992? And how will the ruling shape Ghana's fledgling democracy, public confidence in the Constitution, and the future conduct of presidential elections for generations to come? Whatever the outcome, the Supreme Court's decision is likely to become one of the most consequential constitutional rulings since the advent of the Fourth Republic. For Globe News, Belinda Tetteh.